Portland Family or Relationship Structure Protections. What landlords must change in applications, occupancy limits, and screening. Hey everyone, Mr. Portland Landlord here. If you've been renting in Portland's for any length of time, you already know the city likes to add extra layers on top of state law. The latest one took effect April 10, 2026, and it expands the city's civil rights code to protect family or relationship structure. This isn't just a feel-good addition to the policy statement. It creates a private right of action for discrimination in the sale, rental, or leasing of real property. That means applications, advertising, occupancy policies, and screening decisions now sit under a wider umbrella. The good news? Most of what solid landlords already do, objective criteria, consistent process, and careful language, still works. You just need to clean up a few habits that used to be common. Let's walk through what actually changed and what you should do about it. Portland City Code 23.0.1.030D defines family or relationship structure as the actual or perceived involvement or lack of involvement of consenting individuals in intimate personal relationships. The code then lists examples that include, but are not limited to, multi-partner or multi-parent families and relationships, step-families, multi-generational households, diverse family structures, consensually non-monogamous relationships, and consensual sexual and intimate relationships, including asexual and aromantic relationships. In plain English, the city is treating the shape of a household's personal relationships the same way it already treats race, sexual orientation, gender identity, source of income, and the other protected classes. You cannot refuse to rent, impose different terms, or steer applicants because of how the adults in the household organize their intimate lives. This sits on top of existing state protections under ORS 659A.421 and Portland's FAIR screening rules under PCC 30.01.086. The city simply added another category to the list. Oregon already limits how restrictive occupancy guidelines can be. Under ORS 90.262 subsection 3, any occupancy guideline a landlord adopts cannot be more restrictive than 2 people per bedroom and must be reasonable. Reasonableness looks at bedroom size, overall unit size, and any discriminatory impact on the classes protected by ORS 659A.421. That 2 per bedroom baseline remains fully legal. What is no longer safe is framing the limit as one family only, traditional family preferred, or anything that signals a preference for a particular relationship structure. A neutral statement such as maximum occupancy, 2 persons per bedroom, or this unit is limited to X total occupants based on size, and configuration is still fine. The moment the language starts describing who those people should be to each other, you create risk under the new city code. Portland's already requires specific notices with every application. Those forms still need to go out. On the application itself, drop any questions that probe relationship status beyond what is needed for identifying the people who will live in the unit and who will be financially responsible. Stick to names, ages if relevant for occupancy, and financial responsibility. Let applicants tell you who will be on the lease. In advertising, expand the list of words to avoid. Phrases like perfect for a traditional couple, ideal for empty nesters, family-friendly, or quiet professional household preferred now carry extra weight. Describe the property, not the preferred relationship configuration of the people who will live there. And now a couple shameless plugs. If you want the ready-to-use landlord forms, the latest Portland-specific notices, and a community of owners who actually talk through these changes instead of guessing, join the Portland Area Rental Owners Association at www.paroa.org. The education and the forms library alone usually pay for the membership in the first disputed deposit or screening issue. For owners in the Portland Metro or Central Oregon who would rather hand the whole screening, lease-up, and compliance process to a team that already lives inside these rules every day, the property managers at Northwest Real Estate and Property Management, www.nwrpm.com, handle it so you don't have to keep rewriting your application packet every time the City Council meets. Okay, back to the practical side. Portland's FAIR rules already require published screening criteria, ordered processing, and the chance for supplemental evidence. Those rules did not change. What changed is that a denial motivated even partially by the applicant's relationship structure is now unlawful under City Code. The practical defense remains written, objective criteria applied the same way to every applicant. If 3 adults apply together and meet the income, credit, rental history, and criminal criteria you published, the fact that they are not a married couple or a nuclear family is irrelevant. If they fall short of a published neutral criterion, document that shortfall the same way you would for any other household. A few patterns keep showing up in conversations with owners and managers, using one family per unit language in the lease or house rules, treating multi-adult applications as automatically higher risk without applying the same screening criteria used for couples, marketing that still contains family-oriented or quiet couple language, staff casually asking about relationship status during tours, and failing to update required Portland notices and internal checklists after the April 10th effective date. None of these are hard to fix. They just require a deliberate pass through your forms, ads, and training materials. Here's a simple 6-step checklist. 1. Pull every active listing and strip relationship preferencing language. 2. Review your application form and remove questions that are not necessary for identity, occupancy, or financial responsibility. 3. Confirm your occupancy policy is stated in neutral persons per bedroom/total occupants language and stays within the ORS 90.262 reasonableness standard. 4. Update staff and any third-party screening company on the new protected class. 5. Make sure the required Portland applicant rights notices are still going out with every application. 6. Document every screening decision against published criteria. Do those 6 things and you have dramatically reduced the risk that comes with the new city protection. Quick question for you in the comments. What's the first form or listing description you're going to update after watching this? Portland added a new protected class. The practical response is the same one that has always worked. Neutral language, consistent process, and good documentation. Update the forms, train the people who talk to applicants, and keep the occupancy rules objective. Do that, and you can keep running your rentals without turning every multi-adult application into a legal science project. Hey, if you're a Portland area landlord, come join the community over at www.PAROA.org. We've got education, forms, networking, and we fight for your rights at the legislature. And for owners in the Portland Metro or Central Oregon looking for hassle-free management, check out the pros at www.nwrpm.com. Join www.paroa.org today. Like, subscribe, and comment.